Good afternoon, everyone. Welcome to the antitrust discussion today as part of our healthcare compliance webinar series. My name is Corey Talbot. I'm a partner at Holland & Hart. My practice is a general commercial litigation practice and also antitrust counseling, investigations, and litigation. So today we're going to go over the state of antitrust at a very high level. If you have any questions, feel free to type those in, but we'll get things going right away. First of all, and this is probably the most important point, there's no dash in antitrust. If you don't take away anything else from the presentation today, remember that. All right, so the antitrust laws were put in place to protect competition. And so we've got some statements from the two main federal agencies that address antitrust issues, the Department of Justice, and in their mission page, they state that the goal is to protect economic freedom and opportunity by promoting free and fair competition in the marketplace. The FTC is the other major federal agency that addresses antitrust issues. And this is a snippet from their guidance regarding antitrust laws in 2021. They talked about free and open markets are the foundation of a vibrant economy. And it goes on to talk about the fact that competition gives consumers the benefits of lower prices, higher quality products, more choices, and greater innovation. And that really is the sort of the fundamental driving concern of the antitrust laws and has been for decades. If you've followed anything in antitrust law at all, though, over the last few years, you'll know that the Federal Trade Commission has been unhappy with the way that the agency in the past has enforced antitrust laws. And the guide to antitrust law was recently revised, and the website now does still have language about the fact that the purpose of antitrust laws is to protect the process of competition for the benefit of consumers. But it adds some other things. It talks about making sure there are strong incentives for businesses to operate efficiently, keep prices down and quality up. Now, these are very similar to rewording of what was in 2021 rather. But the fact is that in practice, over the last couple years during this administration, we have seen the Federal Trade Commission and the DOJ take a much more expansive view of what the purpose of antitrust law is. This has been pejoratively referred to as hipster antitrust. And that's got several different iterations of it, but instead of just focusing on consumer welfare, which for decades has been the bedrock of antitrust enforcement, they are now looking at other considerations. They're looking at things like market openness. They're looking for the impact of mergers and acquisitions on employees and employment. They're looking at the concentration of political power. They're looking at the impact that mergers might have on innovation. And these things go beyond the consumer welfare standard. And we'll talk about this a little bit more as we go on. But suffice it to say, the agencies are taking a broader view of the purpose of antitrust law and a broader view of their enforcement powers and obligations in enforcing antitrust laws. So we'll start with, we'll go over some key terms. We'll talk about the various agencies that are involved. We'll talk about both public and private enforcement of antitrust. And we're going to talk about how that works in the healthcare arena. We're going to talk about group purchasing organizations, joint negotiating, boycotts, information exchanges, mergers and acquisitions, and then we're going to talk about what's next. And we will actually jump onto that one a little earlier just because of the way that, that this has been changing very, very rapidly over the last several months. So let's start with some key terms. One of the fundamental terms for antitrust law is the market. And antitrust law uses an economic definition of what a market is as we analyze whether a particular transaction is anti-competitive or not. So a market is an area within which a firm or group of firms could profitably raise prices. And if a firm can profitably raise prices, that firm is said to have market power. So the test that you do to look at that is called the hypothetical monopolist test. And what you look at is whether a hypothetical monopolist could initiate a small but significant non-transitory increase in price, a SNP. And so you would consider that in the context of two markets, the product market and the geographic market. So let's give just an example of how that actually would play out. Let's talk about the product market first to see how that hypothetical monopolist test would play out. So a product market, that's an effort to identify the products that fit into the market that we're addressing. You know, for instance, if you are looking at a merger of two companies that make you know, hot dogs, you're not going to look at likely the market for potato chips. Those are usually not seen as substitutes, that when the price of hot dogs goes up, people turn to potato chips instead. Instead, what courts look at is whether those products are reasonably interchangeable. And so for example, in the product market, let's say that you are a company that sells four-wheel drive vehicles only. Is a front-wheel drive vehicle a reasonable interchangeable use of the product? Maybe it is, and maybe it isn't. It depends on the use, and it depends on how the market breaks out. If people are buying four-wheel drives and not substituting front-wheel drive vehicles, then the four-wheel drive market may be the appropriate product market to consider. But if prices go up for four-wheel drive vehicles and people switch to front-wheel drive vehicles, that may be included in the market as well. The next is the geographic market, and this is the physical territory in which the producers are located and where customers reasonably turn for their supply. And so you would look at the hypothetical monopolist situation test to determine what the geographic market is. And you ask the question, could this hypothetical monopolist impose a SNP, a small increase in price that's not a short-term, it's non-transitory, it's a permanent increase in price, we'll say, for our purposes, in the proposed market. And so the example that we have here is, let's say that we are trying to determine the geographic market for hospital services. And so let's say we look at Salt Lake County. If the hospitals in Salt Lake County could profitably raise prices and not, then that would be an appropriate geographic market. But if the hospitals in Salt Lake County raised their prices and then consumers went outside of Salt Lake County to get those same services, so that it was not profitable for those hospitals to raise their prices, then that would not be an appropriate geographic market. And what you would do is you would add outlying hospitals outside of Salt Lake County until you reach a point where, yes, an increase in pricing would be profitable for those groups of hospitals if they were acting as a hypothetical monopolist. And if that, once you figure out that is that's the geographic market for purposes of your antitrust analysis. So market power is the concern that ultimately the agencies are looking at, and that's the ability to raise price profitably by restricting output. Can you raise price or lower the quality of your product without losing so much business that it's going to make it unprofitable? So market power, you can exercise that on your own, or you can exercise that by coordinating with your competitors. So couple examples there. Let's say, a few years ago, I had a road trip where I was in Moab to start, and about 20 miles outside of Moab, there was a gas station. It was the only gas station within 20 miles either way, and that gas station on its own had raised its prices about $1.50 a gallon higher than gas stations in Moab or gas stations in the next town. That gas station, because it was the only option at that point, had unilaterally determined that it would raise its prices. So that's one way that a market participant can exercise market power, unilateral, and there were no other competitors that would keep that in check. The second example, though, is gas stations working together. And on my road trip took me from Moab down to Las Vegas. And one morning I was walking to a meeting, and it happened to be at an intersection in Las Vegas where 4 gas stations were one on each corner of this intersection. And each of those gas stations were selling gas for exactly the same price. Now, I am not saying that they coordinated that, but that would be an example of competitors in one area coordinating together to set their product prices at the same level. And that type of coordination would be an antitrust violation, or could be rather. So who's looking at these issues? Who's looking at whether organizations have market power and are improperly exercising market power? The first is the 2 agencies that we talked about, that I mentioned earlier, the Federal Trade Commission and the Department of Justice. The FTC does have a group that specifically addresses healthcare issues. When the Affordable Care Act was passed, the incentives under that act led to a significant amount of consolidation in healthcare industries. The FTC, though, pushed back pretty hard on those consolidation efforts, and was very skeptical that mergers or collaboration were necessary to provide more affordable care. Healthcare is a very significant industry for the FTC. This is one where when staff attorneys begin an investigation, it has to go through the commissioners before it can be resolved, even if the result is that the investigation didn't show that there was really anything the FTC needed to look into or do. But because of the high priority that healthcare is for the Federal Trade Commission, those investigations are much more intensive now than they were, say, 15 years ago. The Department of Justice also is involved in antitrust issues. It has the potential to bring criminal actions. Those are rare but not unheard of, and frankly, they are increasing. We're seeing much more activity by the Department of Justice in the criminal enforcement, in its criminal enforcement of antitrust laws over the last several years. And even though the bulk of that that we hear about has been unsuccessful, it does have an impact, and the DOJ is certainly willing to bring those cases much more often than it was doing, again, 15, 20 years ago. State attorneys general are also active in antitrust enforcement, and especially in the healthcare world, the state attorneys general frequently join forces with the FTC to run investigations to challenge transactions or conduct. It's something that provides, it's a benefit for the FTC and the state agencies to collaborate, allows them to be more efficient and have a broader reach in investigating antitrust issues. Competitors are also looking at antitrust issues. They're looking to see if their competitors are engaged in anti-competitive conduct that's harming them in the marketplace. And so competitors are a potential risk that need to be considered as far as antitrust claims. Consumers as well are also potentially involved, often as class action plaintiffs. The private enforcement, these cases are, as far as somebody actually filing litigation, those private actions take up the lion's share of legal court actions involving antitrust issues. That said, it's the enforcement that really gives people a lot of, by the agencies, by state and federal agencies, that really gives people pause. Private litigation is very, very expensive and time consuming, and private challenges to anti-competitive conduct frequently are resolved far short of trial or any sort of judgment that would allow us to gain a lot of insight as to what's going on. But the enforcement by the agencies is where we get much of the guidance that we have today. Okay, so what are the agency's aims? Again, this is the Consumer Welfare Standard, and this has been the bedrock standard for antitrust enforcement for decades. It's not the same as protecting a particular competitor. And so if a competitor is losing market share and losing power in the market because it has high prices or poor quality or limited output, that's fine. It's frankly the goal of competition to drive bad competitors out of the market. And to leave only good competitors who are efficient and able to provide lower prices, better quality, and more output. The new goals don't ignore that, but they add to it. They add to it, and so there are additional considerations. Employment has become a significant issue during this administration. What is the impact of collaborative conduct or mergers, or joint ventures on employment? And what we're seeing is that the agencies are increasingly willing to sacrifice consumer welfare if an issue like employment is going to be significantly impacted by a proposed merger or proposed conduct. So let's talk about some of the actual laws that are in play when we talk about the antitrust laws. You've got federal and state statutes. For the most part, and this is not going to be entirely correct in any state, but broadly speaking, state statutes track the federal statutes that we're going to be talking about, at least some of them. And we're not going to get into the nuances of individual states today, but by and large, what we see in states mirrors or closely resembles what we would see in federal claims. So the first statute that we're going to talk about is the Sherman Act. Okay, and there are generally two types of claims you see under the Sherman Act: a Section 1 claim, and this involves coordination among separate entities, and a Section 2 claim, and Section 2 is more about monopoly and a single entity acting in an anti-competitive way. So Section 1, the three elements of a claim under Section 1 of the Sherman Act: you've got a contract or a combination or a conspiracy among two or more separate entities that unreasonably restrains trade, and unreasonably is where that's where the rub is. What is unreasonable? Anytime you contract with somebody, you are restraining trade. When I go to the store and I buy, buy a box of donuts, there are less donuts for other people to buy, and so I have restrained trade. Have I restrained trade unreasonably? No, I have not. And so that's never, something like that would never be an antitrust issue. But as you get closer to the unreasonable restraint of trade, if I went and bought all the donuts in Salt Lake and contract to buy all the donuts in Salt Lake, that could raise antitrust concerns as an unreasonable restraint of trade. And does it affect interstate or foreign commerce? And again, that's how it becomes a federal issue. If we are going beyond intrastate competition and talking about competition across state or national lines. So the best example, and probably the easiest example of a Section 1 claim, is price fixing. You cannot simply call your competitor and agree that you are going to charge the same price for a product. That type of agreement would be called naked horizontal price fixing. It's horizontal because you are dealing with a competitor that's on your same level of competition. It's naked because there are no pro-competitive aspects to that agreement, and it's price fixing because you are setting the price with a competitor. Naked horizontal price fixing is what we call a per se violation. That means that there are no defenses that would justify a claim like that, and it is illegal under federal law. Just an example of this, 2016 Philadelphia Federation of Teachers Health and Welfare Fund sued 3 pharmaceutical companies, alleging that they had conspired to increase the price of generic fluocinolone, a steroid that's used to treat certain skin conditions, which clearly I am not heavily involved in. The lawsuit basically claimed, look, these 3 got together and they raised their prices significantly. You'll see 635% over a two-year period. And that naked price fixing was a per se violation of the Sherman Act. This is a great example of why you never want to get involved in antitrust litigation as a defendant. This ended up being a complete morass of antitrust issues for these companies, which in some ways are still ongoing. 7 years later, you have class action litigation, you've got criminal investigations and cases that have arisen out of this, and so it's a warning about the dangers of antitrust law. The hot issue right now with price fixing a hot issue that I see a lot of is with wages. Particularly in healthcare, this has been an issue that I have heard several people from several agencies voice concern in healthcare about wage agreements to set wages for example, nurses, which was a big issue during COVID, and there were a lot of organizations that had to adjust salaries for nurses, and that led to at least concerns that hospitals or physician groups were coordinating with each other on the salary of nurses, and that has remained a hot issue with the agencies. Section 2 of the Sherman Act deals with unilateral behavior. So now we're not talking about agreements between 2 firms or entities. We're talking about unilateral conduct. And the Sherman Act prohibits monopolization, attempts to monopolize, and conspiracies to monopolize. And I want to be clear. You do not, simply by being the very, very best at what you do and driving all your competitors out of the market, violate Section 2 of the Sherman Act. If you're a monopoly because you're the best in the business and you beat everybody else, more power to you, at least under the Section 2 of the Sherman Act. It's not enough just to have monopoly power. What you have to have is the willful acquisition or maintenance of monopoly power by exclusionary conduct. And that is conduct that keeps other competitors out of the business, out of the that industry, or prevents them from efficiently operating in the industry. And so the FTC believes that courts are way too lax in enforcing this provision of the Sherman Act. And we'll talk a little bit about some of the things the FTC is doing to push back on that. These types of claims used to be really, really uncommon in healthcare, but the FTC in particular has shown a real willingness to pursue these types of claims now, and in healthcare and in other industries. So let's give an example of that, just so you can see what I'm talking about. This is one that I think shows why this sort of Section 2 claim can be really, really tricky. A predatory pricing claim falls under Section 2 of the Sherman Act. And the notion is that what a business is doing is it is pricing its product below its costs for the purpose of driving out competition. And then after the fact, what would happen is that, after that business drives away all the competition, it's going to hike up its prices significantly beyond what is the appropriate market price for that product. And easy example of this, in 2013, booksellers started claiming that Amazon.com was offering books below the prices of those of its brick and mortar competitors. So for instance, Amazon would buy a book for, let's say, $15, and then Amazon would sell it online for $10 with the goal of getting consumers to buy only on Amazon and not at local bookstores. That would drive the bookstores out of business. And then Amazon, because it can do that and still make enough money in its other areas to be profitable, once those bookstore competitors are gone, then it can raise its prices as much as it wants, and not, significantly beyond what the market would normally bear, because it doesn't have any competitors. This challenge, and here's the problem with that. If I'm a judge and I'm looking at this case and somebody says, well, gosh, Amazon is selling books at a really low price, and I am looking at the goal of antitrust law as being the consumer welfare, I'm saying, well, this is wonderful for consumers. They're getting a really good deal by buying a book from Amazon, and that is a great thing. And so Section 2 claims like this can be really, really tricky in practice. The next statute that we're going to talk about beyond the Sherman Act is the Clayton Act. You've got several different sections of the Clayton Act. And Section 2, and this is often, claims under this are often referred to as Robinson-Patman or Rob-Pat claims. Those prohibit price discrimination in the sale of goods. And so the gist of it would be, let's say I work at a gas station and I'm selling a candy bar, and I'll sell it to somebody for $1, and I'll sell it to somebody else for $1.50, because I'm going to discriminate between consumers. And that would be a potential Robinson-Patman violation. There are exemptions in the Clayton Act that relate to purchases by nonprofit entities, and that includes hospitals, health systems, hospice providers, and so forth, that purchase supplies for their own use. It gets a little tricky at the edges of how that works, but there is that exemption, which is really helpful in the healthcare arena. By and large, the agencies for decades have shown no interest in enforcing the Robinson-Patman Act. However, recently, and not surprisingly, given the change and emphasis on antitrust enforcement in this administration, we have heard of the agencies investigating Robinson-Patman violations. And so this is one that I think many practitioners viewed as a dead letter. which is now important when it comes to enforcement. Section 3 of the Clayton Act prohibits exclusive dealing arrangements, tying arrangements, requirement contracts that tend to substantially lessen competition. And that's the trick. What does it mean to substantially lessen competition? Exclusive dealing arrangements are very common, tying arrangements as well, and requirement contracts. Again, these are the types of contracts people enter into all the time. But if you get to the point where your market share is high enough that it substantially lessens competition, for you to have one of those types of arrangements, they can be problematic. Section 7 of the Clayton Act prohibits acquiring stock or assets that may tend to substantially lessen competition or create a monopoly in a line of commerce. And so you're looking at a merger, you're looking at an acquisition, and how that's going to impact competition. And the agencies have a lot of leeway here. Now, initially, this was set up to be an incipiency statute. So you can go out and you can investigate and challenge a transaction in its incipiency. You don't have to wait around and see how bad this gets before the agent. If I'm at the FTC and I'm concerned about this, I can challenge it now instead of waiting to see how bad this transaction actually is for competition. On the flip side, there's no time limit to a challenge, and the challenge can and sometimes does, not very often, but sometimes does come after the transaction, and the parties are forced to unwind a transaction. That gets very, very messy, both for the firms involved and the agencies. So it's something the agencies try to catch before those transactions are finalized, but oftentimes that's when they learn about it, and that their investigation shows that they should do that, and that's what they do. So some examples of this, probably the really big news a few years ago was the DOJ blocking the mergers of Aetna and Humana and Anthem and Cigna using Section 7 of the Clayton Act. And the Attorney General at the time was very concerned about those mergers, saying they would fundamentally reshape the health insurance industries, leaving much of the multi-trillion-dollar health industry in the hands of three mammoth insurance companies. I think that's helpful to use that as an example. One, because it's a big enough example that I think most people who follow mergers in the healthcare industry would have heard of this, and because it does show when these types of mergers really become problematic. You have these arrangements that reduce the number of major competitors in an industry, in this case, in the DOJ's view, from 5 to 3, putting these two transactions together. And that's when you reduce a very small number of competitors to an even smaller number through a merger or acquisition. That really is when things get problematic. If you have a much larger, less consolidated market, if you have a less consolidated market, let's say you have 30 competitors in there, and you have two of those competitors that want to merge, well, depending on their market share, that may not be a big deal at all. But if you've got 5 and they're going to merge down to 4, or 4 and they're going to merge down to 3, that's a concern that you're losing competition in a highly consolidated market. Here's another example, and this is one that's in our geographic footprint, so we use it because many of you are familiar, have heard about this, or have seen analysis of this. And this is a St. Luke's case in Idaho. St. Luke's actually did acquire Seltzer, which was an independent physician group. And the FTC, after the fact, alleged that the acquisition included the right to negotiate health plan contracts and establish rates and charges. At the same time that the FTC was bringing this challenge, St. Alphonsus, which was a rival, of St. Luke's, alleged that it would give St. Luke's a dominant market share and allow it to block referrals to St. Alphonsus. The court, in that case, determined the transaction did threaten competition and ordered the divestiture of the acquired physician group. So the court undid the deal. The relevant geographic market was key because the St. Luke's tried to argue that the physician group, the relevant geographic market included the greater Boise, Idaho area, and the court was not convinced of that and did a much smaller, determined that there was actually a much smaller geographic market. And the smaller the geographic market is, if you're a defendant, that's usually worse. And so they did a divestiture instead of other potential remedies. Other potential remedies would have been behavioral remedies, so-called, where the agencies oversee the conduct of the parties. The agencies don't like that. They don't like to have that kind of oversight responsibility that pulls resources away from other potential claims or investigations. So what was important? St. Alphonsus really pushed the notion that the acquisition would foreclose competition, eliminate incentives to refer patients to the outside group. And the FTC said that the acquisition would give St. Luke's the ability to extract higher rates from commercial payers. So you had a couple different emphases in that case as to why it was bad for competition. Ultimately, the Ninth Circuit Court of Appeals affirmed that ruling, and they did have to unwind that deal. Another example, and this is one back east, was the merger of Thomas Jefferson University and Albert Einstein Healthcare Network. The FTC challenged that transaction and lost. They lost it based on the witness credibility and issues surrounding how markets were defined. And this is one where the FTC tried to draw a very, very narrow market using the hypothetical monopolist, and the court just was not convinced that the market was as narrow as the FTC indicated that it would be. This one is interesting because it does show the political aspects that potentially relate to larger antitrust cases, as there was much talk that change in administration played a hand in how that went. The next section of the Clayton Act that I want to talk about briefly is Section 8. Section 8 prohibits what are called interlocking directorates. And the notion is, if I am on the board of directors at, say Shell Oil, I should not also be on the board of directors of Chevron, because those are companies that compete with each other. And I should not be acting on both boards. Interestingly, the penalty for a violation of Section 8 of the Clayton Act is that is nothing. There is no penalty. What you'll get is a letter from the FTC that says, hey, you have an interlocking directorate, stop it. And the firms then have to take steps to stop that. But there's no penalty associated with a Section 8 violation. What happens though, and this is where there's a real risk from this, is the FTC tends to do this in a way that is very, very public. And it is essentially waving a red flag to plaintiffs' antitrust attorneys that, hey, these two companies that are supposed to be competing with each other have interlocking directorates. And you might want to look at whether they have really, really been engaged in fulsome competition. And that risk can be significant. And so the publication of those interlocking directorate investigations can be very problematic for companies, and that's why it's important to consider that as you're looking at who your directors are. Private parties can enforce the Clayton Act or the Sherman Act under Section 4 of the Clayton Act. And what that section does is it provides a significant incentives for plaintiffs, and that is you get triple damages. And so if I am a plaintiff in an antitrust case and I can prove $1 million in damages, my recovery is $3 million. You triple or treble the damages that you've incurred, and so that's an incentive. So these statutory schemes do not exist in a vacuum. You've got now decades and decades of case law, and you also have guidance, formal guidance from the agencies, and by the agencies I'm referring here to the FTC and the DOJ. The FTC has traditionally issued horizontal and vertical merger guidelines. There were new vertical merger guidelines that were issued during the Trump administration. Shortly after the Biden administration came in, it withdrew those vertical merger guidelines. And just about 2 weeks ago, the agencies issued new draft proposed merger guidelines that combine guidelines for horizontal and vertical mergers. These merger guidelines have a very, very different approach to antitrust enforcement than we've seen in the earlier merger guidelines. First, they lower, and just a few, there are a lot of things we could go over in this. They lower the threshold for a firm's post-merger market share that would lead enforcers to challenge a transaction. As far as I'm aware, for example, no court has ever said that a 30% market share was dominant, such that it would lead to an antitrust violation. But that's the threshold now that the agencies are proposing, that 30% market share. The guidelines also focus on harm to workers. I've mentioned this a couple of times, but you can have deals where if they were considered under these proposed merger guidelines, would fail even if they did benefit consumers if there was significant harm to workers. And what the merger guidelines have done is they set out 13 different scenarios, deal scenarios that could be deemed anti-competitive and illegal. And that's helpful, but it also has enough soft language in there that the guidance that's provided by those different scenarios is not as doesn't create a lot of bright line guidance for parties. It does some, but not a whole lot. For instance, they emphasize that these guidelines are non-binding and that enforcers can exercise their discretion in bringing actions that may not fit neatly into one of these categories. And the 13th category, by the way, is a catch-all, just saying that, hey, these other 12 scenarios are not exhaustive. And so there are some real concerns about how that will play out in practice. When the agencies came out with these proposed merger guidelines, U.S. Attorney General Merrick Garland said, "Unchecked consolidation threatens the free and fair markets upon which our economy is based. These updated merger guidelines respond to modern market realities and will enable the Department of Justice to transparently and effectively protect the American people from the damage that anti-competitive mergers cause." And so this is one where, on the one hand, I think it's good to have these proposed merger guidelines, because what we've had for the last year and a half is a lot of uncertainty, because what we've seen is the agencies have withdrawn significant amounts of guidance and sort of left us scratching our heads trying to figure out, well, what are the agencies going to consider competitive or anti-competitive transactions? And so this does provide some guidance to that. And what what this hopefully will do is allow decision makers at firms to have some insight on what kind of transactions they can or should be looking to engage in. Because right now what we've had is a bottleneck with firms unable to decide whether they want to pursue a transaction because there's no guidance from the agencies on what conduct is going to be investigated. Interesting point in combining the vertical and horizontal guidelines, though. There has been a significant enforcement effort by the FTC on vertical mergers. And so far, the interesting thing about it is that the agencies have lost the FTC's lost every one of these that it's actually brought in court and challenged under its theory that these vertical mergers will harm competition. And the FTC is actually okay with that. They're fine going in and losing these vertical merger cases because having this enforcement emphasis has reduced the number, they claim, of vertical mergers that are actually presented to the FTC or DOJ for approval. And so even though courts are not buying the vertical theories that the FTC is raising so far, they are still, the FTC still believes that they're effective. That is where these guidelines, it'll be interesting to see how they play out, because you'll have this guidance from the agencies, you'll have the agencies actively working to enforce this guidance, but you've got 40 years of case law that does not support some of the things that these merger guidelines are emphasizing. So just a quick example of how this might play out in healthcare. One of the merger guidelines, this is guideline number 7, says that a merger should not entrench or extend a dominant position. And so here's one where you could have a cross-regional merger strategy. So let's say you have two firms that do not compete with each other. They're in different geographic regions. And let's say that you've got a health plan in one region wants to merge with a health plan in another region. Is that problematic? Well, if we look at the product market, they don't share a product market. They're in different markets, so is that really a problem? And I think a lot of antitrust attorneys would say that's a real sign that this is not going to be anti-competitive and should not be considered. That really cuts against a claim that there's an antitrust violation. But what the proposed merger guideline now says is that if those health plans are considered dominant, or one of those is considered dominant in its home market, even if it doesn't compete with the target, that can still be deemed an anti-competitive contract, a merger. And what that means is the agencies are going to say this is presumptively illegal and investigate and or challenge that transaction. And while the health plans may have good defenses in court, a lot of times that's enough for the FTC to come in and say, we think this is presumptively illegal and we're going to investigate and challenge this. That's frequently enough to end a deal. And that is something that is really a feature and not a bug. Just last week, Chair Lena Khan of the FTC testified before Congress about these very issues and the fact that they're bringing theories in court that are just losing every time they bring them. And she essentially said, I'm okay with that. They were talking about 2 specific cases, and she said losing 2 is okay. And her rationale was that the agency has forced parties to abandon deals in the face of a challenge. and said, depending on how you look at those, we've forced 13 to 20 mergers that in our view would have been anti-competitive to scrap the deal without having to challenge that. Now, there are healthcare specific guidance that we have from or had from the agencies. The DOJ statement of and FTC's joint statement of antitrust enforcement policy in healthcare has been scrapped. Statement of antitrust enforcement policy regarding accountable care organizations, gone. The overview of FTC actions in healthcare services and products has been significantly updated. And frankly, given that it was a year ago, I would not be surprised if it's updated soon again. We have a lot of guidance that has gone out the window, and that puts healthcare in a bit of a pickle, because we don't have a lot of clear guidance on issues where we had clear guidance in the past. For example, one of the policies that was done away with was a 1993 policy that established an antitrust safety zone for mergers where one of the merging hospitals is small. Okay, so this is a hospital that is with fewer than 100 licensed beds and fewer than 40 patients daily on average. And the FTC and DOJ had said, absent extraordinary circumstances, they're not going to contest a purchase of that hospital. And the rationale was, we want to protect small rural hospitals so that they're not that need a merger in order for them to keep running. And that guidance is now gone. Now, it doesn't mean that the FTC and DOJ are going to emphasize those types of transactions going forward. But what it does do is create uncertainty for a potential merger. The parties aren't able simply to say that it doesn't look like there are extraordinary circumstances, so we're going to be okay with this merger. Instead, they have to do a much more robust antitrust analysis as part of the transaction to determine whether this is going to cause concern from the agencies. The reason that this guidance has been withdrawn is because of what the FTC says is a profound change in healthcare markets over the last 3 decades. And as a result, they claim that the statements no longer provided accurate guidance to market, no longer served their intended purpose, and didn't provide accurate guidance to market participants. And so as a result, we're sort of left out in a little uncertain situation, and it's not clear where a lot of this guidance is going to end up. But we're optimistic that we're going to get additional guidance from the agencies soon. Healthcare is, I mentioned this earlier, healthcare is a major emphasis of the agencies, the FTC and the DOJ, and there are many reasons for that. It's a highly regulated industry, and so you've got really conflicting incentives as a result of legislation and regulation that doesn't show up in a lot of other industries, and that makes antitrust enforcement important for the agencies, because they are left to police the regulatory compliance of many healthcare entities. And this is something, there's bipartisan support for increased antitrust enforcement. Where that breaks down, though, is what that means with antitrust enforcement. You've got one side saying we need to rethink how we are, what our priorities are under antitrust law, and this is what we see now is an expansion of objectives under antitrust laws. And then you've got another side saying, no, it's the consumer welfare, but we need more enforcement based on consumer welfare. And so whichever theory you subscribe to, antitrust enforcement is likely going to consider for the increase in the foreseeable future. So against that, let's say that you're dealing with an antitrust issue. How do courts look at alleged antitrust violations? There are a few ways, generally speaking, that courts look at antitrust violations. First, they're per se antitrust violations. I mentioned this a little bit earlier when we were talking about price fixing. That's conduct that's illegal per se, with no need to analyze anything more. Naked horizontal price fixing is a per se violation. Customer allocation, you'll stay on the west side of the valley, I'll stay on the east side of the valley. We won't compete with each other at all. That's a per se violation. That kind of a naked agreement to allocate market is illegal. The other analysis, though, and this is really the case, is we look at antitrust cases under a rule of reason. And that's where conduct may or may not violate antitrust laws. You remember we saw the standard earlier. Does this merger, does this acquisition, does this conduct substantially lessen competition? Well, there are upsides and downsides to various transactions. And over time, courts have come up with what they call a quick look review, where they're pretty sure it's illegal, or a full-blown review where there may be such good benefits to this, we need to consider whether this particular transaction really is an antitrust violation. On the defense side of a claim like this, what you want to do is emphasize a lack of market power, or show that there are significant pro-competitive benefits to the transaction. Any proposed restraint on competition must be reasonably necessary to produce the claimed efficiency. And this is one where historically what parties have done is they've said, look, this transaction will allow us to compete more efficiently, and that's going to be better for consumers. Well, you can say that about almost any transaction, and the question is whether it's really true. And so this is a defense that in the proposed merger guidelines has been really, really pared down, and the burden on a defendant has been really, really increased to show that the merger will be more efficient. Another potential defense that parties frequently use is what's called the failing firm defense, and that's where, barring this merger, barring this acquisition, this firm is going to go out of business, and so we're not reducing competition, we're preserving competition. And again, that's when the agencies are very skeptical about those types of claims, mostly because everybody makes those claims to defend. And really what we see is this rule of reason analysis is essentially, they're a continuum of analysis now, and it's on the parties to show the evidence one way or another. And courts historically give some things more credence than others, but the FTC is really pushing to eliminate a lot of those defenses, or raise the bar for them, not eliminate, raise the bar for those defenses. So we talked about some of these examples already, naked price fixing, naked no poach agreements. You don't hire my people, I won't hire your people. Those are per se illegal under the antitrust laws. Rule of reason, that would apply to, say, a supply agreement, where we're not competitors, but we enter into this supply agreement. You supply me with materials that I use and then pass on to consumers in a different form. That sort of contract is judged under the rule of reason. Joint ventures give rise to the same issues as mergers by and large. And so you would look at the same type of factors, and we're running short. Well, we're running out of time, so I'll go ahead and move on with that. But these group purchasing organizations are examples of joint ventures that, over the last few decades, have been a source of certainty for parties, and there were safety zones that allowed you to enter into a group purchasing organization, and as long as you fit within the parameters of that and you can see the percentages there, you were going to be okay, and you didn't have to worry about an antitrust violation, and you would get the benefit of the group purchasing power. That's gone. That guidance has been withdrawn. Now, are the FTC and DOJ going to challenge a bunch of these now? I doubt it, but that guidance is gone, and we don't know for sure. Mergers, again, you've got, this is something that has become increasingly common, especially in the face of the Affordable Care Act, where there are real incentives to consolidation. And the agencies are skeptical about these. We're seeing states becoming much more skeptical about these as well. Information exchanges are another area where there was a safe harbor, and you knew what information you could share with no antitrust risk, and that guidance is gone again too. Vertical acquisitions, it's a new day. Historically, these have not been traditionally enforced or claimed to be antitrust violations by the agencies. Private parties have not jumped on these types of claims, but it's a new day, and the agencies are actively investigating and challenging vertical acquisitions in really an unprecedented way. Boycotts are illegal per se under some situations, as you can see there, and in others they're examined under the rule of reason, but a boycott does give rise to potential antitrust claims, and so to the extent that comes up, that be aware that is a potential anti-competitive agreement that could violate antitrust laws. In joint negotiations, the agencies had provided some really good guidance about financial and clinically integrated healthcare organizations and how they could work together and jointly negotiate. That guidance has been withdrawn. And so again, we're left outside now with a little bit of uncertainty. Certificates of public advantage. This is an interesting way where states trump the FTC enforcement of antitrust and allows deals to go forward as long as the state approves it, even if the FTC thinks it would be harmful to conduct. The FTC hates these and it thinks they are problematic and challenges states' ability to do this frequently. So what's next? Look, we know that there's broad partisan support for antitrust reform, but not surprisingly, that differs in what reform they want. It's interesting. A lot of what the different parties want for antitrust enforcement, they agree on, but they're not willing to move on the other parts and not willing to move simply on what they agree on. And so we're in limbo, like much of what goes on in Congress, I suppose. We do have the new guidance from the proposed merger guidelines, and we'll see. We've got another month and a half of comment on that before those could potentially be finalized, and we'll just have to see how that goes. Are we going to see an expansion of hipster antitrust, some of these expansion of the theories and objectives of antitrust law? If the FTC has its way right now, yes, we will. There are also, for significant transactions over about $112 million now, those have to be vetted with the, depending on whether they're exempt, they may have to be vetted by the DOJ and FTC to proceed. And those are that the FTC is significantly revamping the filing requirements for those that would add significant burdens on filing parties, and we'll see if that gets approved too. So overall, we have a lot less bright lines than we used to have in antitrust enforcement. It's really a new day where the enforcement agencies are being much more aggressive than they've been in the past, and in areas where they have not actively been involved in enforcement for a long time. We can expect that, at least for the rest of this administration, they are going to be very skeptical of consolidation. And in fact, this statement from the new merger guidelines shows that. Surely one premise of an anti-merger statute, citing Section 7 of the Clayton Act, is that corporate growth by internal expansion is socially preferable to growth by acquisition. And so for the foreseeable future, the agencies are going to focus on healthcare too. And it's going to take us some time to get some clear guidance in healthcare. If you have any questions, please feel free to reach out. I know I had to rush that a bit at the end, but if you do have questions, let me know. Otherwise, thank you so much for listening in today, and I'll let you get back to your day now. Thank you very much.